but he just kept saying, no methodology, no methodology, no methodology. And does that ring a bell? Didn't we hear that repeatedly in the Daubert-Lanigan hearing for Dr. Russell?
Not only that, but also methodology, saying there's no methodology after there's a video that's mysteriously like not showing up and that there's seemingly no methodology for anything on the state side regardless.
Well, the generally new attorney for the Karen Reed team, Robert Alessi, got up, and he had pretty much had enough of it, and he pointed out, hello, there's plenty of methodology here.
Green is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case.
By the way, all that paper rustling is in that court. I mean, there are open microphones. There are open microphones everywhere. I shouldn't step on Mr. Alessi because he made a good argument.
And that is with regards to the search of House Long to Die in the Cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously presided over that trial. Your Honor did not issue after his testimony any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution after his testimony stand up and ask for any such limitations or qualification.
And then Attorney Alessi went way down into the weeds of the affidavits, pointing out that not only did Richard Green use an incredibly detailed methodology, but it was the same methodology, which we're going to see in the document in a minute, the same methodology that was used by the Commonwealth's two experts. So it seemed that what was happening here was that the Commonwealth Special Prosecutor Hank Brennan doesn't agree with what Richard Green is going to say. He doesn't agree with the final conclusions. And you know what that is? That's a typical battle of the experts. And that is something for the jury to decide. Basically, what Lanigan and Daubert ask is whether the witness, the expert witness, is qualified. Do they have the background, the education, the training, the experience? And is there science that they're basing their testimony on recognized, peer reviewed? Do other people recognize that it's a reliable method of coming to a conclusion? And that was fairly clear in the first trial. You can say it has been debunked, but it seems to me, and correct me if I'm